Hello, everyone, and welcome to Politico Live. My name is Nick Vanacore. I'm Politico's tech editor, and I'm happy to launch the 4th edition of our AI Summit. We're thrilled to have the opportunity to host this summit virtually, and we hope you enjoy the conversations that will take place throughout the day. We're bringing top thinkers and influencers together to discuss the hottest issues in EU tech policy and beyond. This is well timed because we've just had the publication of Europe's AI package, so just in time. We'll have interviews, panel discussions, interactive roundtables, and spotlight conversations. And we'll be talking about everything from the AI package to data protection, international cooperation, and cybersecurity, just to name a few of the topics. I'd like to thank our leading partner, Microsoft, for making this event possible, as well as our presenting partners, NVIDIA and Google. Before we start, just a few housekeeping rules. You can ask questions and answer our polls only through the Swap Card app. The instructions you'll find on our website. If you're already on the app, you can already chat with your fellow attendees and ask questions in the chat box to the right of the screen if you're on a desktop, and below the live stream if you're viewing on your mobile. You'll also have the opportunity to answer polls at the beginning of most panel discussions. We want to make the event as interactive as possible, so don't hesitate to tweet about the event with the hashtag #PoliticoAI. Now I'd like to kick off this year's event by introducing Didier Reynders, European Commissioner for Justice and Consumers. Good morning, Mr. Reynders.
Good morning.
Good morning. Thanks for being us. I want to start the conversation by diving right into an issue that I know is on the minds of a lot of people watching us today, and that's transatlantic cooperation, especially data flows. This must be top of your pile most days. We haven't had a replacement yet for Privacy Shield, and just the other day, the European Data Protection Supervisor cast some doubt on the use of cloud services by US providers like Microsoft by European institutions. How soon are we going to get a replacement for Privacy Shield? And how are those discussions going, Mr. Commissioner?
So, first of all, I want to say that we have started to engage with the US administration since a long period of time, because we have tried to engage before the Schrems II decision in the way to prepare the process for a new evolution if it was needed. And of course, after the Schrems II decision, it was important to have an acceleration in our contacts. And I want to say that with the new administration, I'm in charge of the negotiation, and we have engaged with some meetings at the technical level, of course, but also with direct talks with my counterpart, the Secretary of Commerce, Gina Raimondo, and also with, of course, Mary Gardner as Attorney General, very involved in the process. But what we try to do is maybe not to go to a quick fix and to try to have shortcuts to find a solution in some weeks, because you know that we have had the Safe Harbor, then the Privacy Shield, and we try to avoid a Schrems III decision. So we want to have a solution in full compliance with the binding ruling of the Open Court of Justice, the Schrems II decision. And so we are working, in fact, on 2 tracks. The first one, in a short term, how it's possible to come with a new mechanism or new safeguards to try to help the businesses on both sides, because it's a priority for the US, but I must confirm that it's a priority for the European Union to find a way to help the businesses to organize trade and to exchange data. And maybe this week, because we are at the end of the process, we will come with the modernized standard contractual clauses to give a new instrument, a new tool in full compliance with the GDPR, and also with the Schrems II decision. And then we continue to work with our US counterparts about the evolutions in the way to have a successor to the Privacy Shield. And so I'm looking forward the evolution in the US about a possible federal privacy law. You have seen many developments in the same way than the GDPR in California. We have seen the same kind of development in Virginia, but now there are different states where it's possible to think about a privacy law, and why not maybe at the federal level. And of course, we need also to see how it's possible to enforce the citizen rights from the European citizens before a jurisdiction in the US, and that is in line, of course, with the national security issue. So, in short, we are in a very good way to talk with our US counterpart, but first of all, with a concrete solution for the short and medium term, and then to try to engage a lot about a more sustainable and robust solution for the longer term on the basis of the binding decision of the Court of Justice.
Right. You said you don't want to fix in a couple of weeks. I do want to get a general sense. Do you expect this to be, is this a question of 2021? Or are we talking more about your term at the commission before? Is this something you want to get done before you go on to do something else interesting outside of the European Commission? Are we talking years or are we talking months?
I'm hoping that we are talking months to find a way to have an agreement on a solid basis. But of course, then you know that we have procedures to go to an adequacy decision. And also, it's not in for this year. I'm sure that we will be at the end of the process. But I try to see if it's possible to have a first presentation of the state of play in the next EU-US summit in June. So next month from tomorrow, and then to see what are the next possible evolutions. But again, the main concern is to be sure that it's possible to enforce the right of EU citizens about their privacy, and that will be before a jurisdiction in the US, and that's the most important and very clear requirement from the Court of Justice.
I understand that. And do you get the sense that this administration has a sense of urgency around this transatlantic privacy deal? What kind of vibe are you getting from the Biden administration officials talking about, especially these things, means of redress for EU citizens in front of US courts? That's been an evasive one for as long as I can remember. How committed, how urgent do they feel about this?
No, we have the sense of urgency on both sides. I must say that I've started to discuss after some days in office in December 19 with the previous administration and before the Schrems II decision. But now that we have the Schrems II decision and the new administration in place, I must say that the real sense of urgency on both sides. And so I've had different talks with Gina Raimondo since the installation of the new administration. We have exchanged different documents, and we have, first of all, technical talks, of course, between our services. And I must say that we have made huge progresses in the way, first of all, to understand the requirements on both sides of the ruling of the Court of Justice, and we have exchanged very concretely about, I said, the most important requirement, the way to be sure that it's possible to enforce the citizen rights. And that's the most important element to be able, at the end, to go to a real jurisdiction. It's in such a way that we are analyzing the situation with many other third countries, if I may, many other partners. I'm thinking about the situation with UK.
Can I get you right on that? Indeed, not the only adequacy deal we're talking about, right? Because there's a question now about sending data back and forth to the UK post-Brexit. I want to get your reaction to some comments that we had just the other day reported on Politico saying, well, of course we want adequacy with the European Union, but if we must diverge from EU data protection standards for our economic interest, then so be it, we'll do that. How do you react to that? There's been a lot of pressure saying, watch out for the UK's data protection environment, and quite a lot of tension around there. How do you describe, are you vigilant? Are you on the lookout for divergence, signs that the UK is pulling away?
But like for trade, like for the TCA, we have for the first time a very specific relation with UK, because you know that in the negotiations with many partners in the world, we try to converge. And like you said, here we try to avoid a divergence in the future between UK and the European Union. So it's very new, because of course the different rules in UK are the same for the moment that than at the EU level, because it was a clear decision in UK to implement the GDPR and to implement the Law Enforcement Directive in the UK legislation. But but we are thinking that it's needed to work on two different elements. The first one is to be sure that also now we have a clear compliance, not only in the rules, but also in the interpretation and application of the rules. And you have seen maybe recent decisions of the European Court for Human Rights or a Court of Appeal in UK about different aspects, and certainly about the migration issue. It was one of the most difficult. And so we are analyzing the situation to see if it's needed to adapt our adequacy decision to those last decisions in justice. And the second issue is for the future, of course. And we have taken into account the possibility to see a divergence in the future. So it's the reason why first, we have for the first time a sunset clause in our adequacy decision. So in any case, after 4 years, we need to restart the process and to have a new decision. Also, if the UK is in full compliance with our rules. And the second element, it will be possible to suspend or to stop the process if there is a divergence in the future.
And that's interesting.
Yes.
If I just ask you on that, isn't it, I mean, just politically speaking, how did you take those remarks? Because the adequacy deal isn't on the table yet. And there's someone already saying, oh, hold on, we're ready to diverge. What kind of political message does that send? And how do you take that?
Yes, but there's all the time a difference between political declarations and a real new law on the table or new bill on the table of the Parliament. And of course, we will analyze all the possible evolutions in the UK. But for the moment, we have launched 2 adequacy decisions on the basis of the GDPR and the Law Enforcement Directive. And we have seen the reactions in the Parliament, European Parliament, so we try to take into account different remarks in the way to amend our adequacy decisions, and the same with different actions that we have seen in the last weeks, and certainly I have said the last decisions of different jurisdictions. And for the moment, we are in discussion with the member states, the so-called comitology. We try to discuss with the member states about the way forward. And again, we will be, like you said, very vigilant, because for the moment it's quite clear we have the same rules in the UK than at the European level, because it was a clear commitment from the UK authorities to implement the GDPR and the Law Enforcement Directive. But of course, we need to verify the interpretation and application, and that's maybe more in line with the last decisions in justice. But we need also to be ready to react if there is some change in the future.
Mm-hmm. All right, so you heard that. Vigilance, ready to react on divergence. I want to get us on to AI. It's the AI Summit. All these things are relevant, but we have an AI package on the table. You've made the proposal. Now it's going into the EU sausage-making factory. Now, there's been a lot of discussion about these proposals, some support, some criticism. Obviously, that's a new law. One of the things that has focused a lot of attention, well, there's two facts. One is basically the carve-outs for police and security forces to use AI, and the other one is really honing in on facial recognition. Now, we've had some pretty big voices, the EDPS again saying, I'm going to go to a fight over facial recognition. I'm just wondering how you have taken some of these responses, and if from your end there's any sense of, well, we'll be ready to move a little bit, for example, on the question of live facial recognition. Is that something where we could see the law being adapted to match some of these concerns?
Now, of course, I will speak about the facial recognition, but let me just say one word about the transition between our previous discussion and this one.
Sure.
Like for the GDPR 3 years ago, we are trying with AI to have a new legislative framework with a balanced approach. So we try to explain that we want to develop AI, like we want to develop all the digital technologies at the EU level. So we want to be able to have innovative process, to have investment, research, maybe education, to have new skills in AI. And so it's very important to us to encourage the development of AI technologies and investment at the EU level in such a way. But we try to do that with a real protection of the fundamental rights. And if you look to the legislative framework about AI, it's in the same way than the GDPR. And I'm hoping that it will be possible for the European Union to lead by example, like it was possible in many regions in the world with the GDPR. And of course, when we are doing that, when we speak about fundamental rights, we need to think about possible discriminations, possible high-risk sectors, but also some possible techniques and technologies, but not to ban some technologies. Right. It's not to say we don't want to develop those technologies. It's just to think about the possible use of one of another technology to protect the citizens. And of course, there you have the facial recognition. And of course, to be very clear, there's a prohibition of real-time remote biometric identification in publicly accessible places by law enforcement authorities. And so it's a principle. Okay. And then you have exceptions. Just to give an example, and you have seen that in Paris, in Brussels, in London, and unfortunately in many other cities in Europe. When you have a terrorist attack, of course, it's important to say for such a period of time, just after the event, you need to open the door for such a kind of technology. The same if you have a specific crime in a specific area or an identification of the author of such a crime in a specific period of time. So we need to say all the time, first, you need to have a European law to do that, or to have a national law for very important public interest. And again, I'm saying that because when you speak about the facial recognition in the public areas, it's a prohibition that we have put into place with very clear exceptions. And now we will engage with the Council and the Parliament to see how far it's possible to go. And you know that the pressure coming from the member states, and I fully understand that, it's maybe to give more possibilities for law enforcement authorities in some member states, but we have also the discussion in the Parliament to try to limit that. But again, it's the use of such a technology, not the development. We are knowing that the technologies are there, and we want to be able to develop those technologies in Europe.
Right. Just to give our viewers a little bit of context, what people are concerned about is that exception that you just mentioned, maybe not the terrorist attack, but the criminal using live facial recognition in the event of a criminal act. To some people, that seems like a pretty wide door. You could say there's a crime going on just about every minute of the day, unfortunately. And I think that's where we'll see some of this discussion really zoom in and really focus. I want to bring you on to another subject, which is part of your portfolio. In a couple days, we're going to be celebrating the 3rd year of GDPR. Remember that Europe's flagship privacy legislation is turning 3. And the question I want to ask you is to get your honest sense of how we're doing with the GDPR, because there have been some questions around enforcement, in particular with the AI rules. You've made the decision to bring enforcement, more of the enforcement power, into the Commission, to centralize it in Brussels. And I'm wondering, do you think there are any lessons to be learned about enforcement in GDPR? We haven't seen the big penalties come down on big tech quite yet. So is there a need for change on that front as the GDPR turns 3? Thanks.
So first of all, thanks for your first remark about the fact that it will be an important discussion with the Parliament and with the Council to see for what kind of crimes it's possible to use such a very invasive technology like the biometric, the facial recognition, biometric facial recognition. And that's very important. So to say, of course, we have there a discussion with the co-legislator to see what is possible to do with a balanced approach. But then about the evolution in the application of the GDPR. First of all, 3 years after the entry into force, it's important to say that it's a good example of what is possible to do with a real development of our security policies, our trade policies, but with a real protection of the personal data. And I said it's an example in many parts of the world. You have seen legislations in the same way in many parts of the world, also sometimes in some states. In the US, I said. The second element, it's very important to say that It's not the moment to try to change the GDPR. Of course, there are maybe some discussions on some specificities of the GDPR, but the most important element, like you said, is the enforcement. And when you compare with AI, of course, we will continue to apply all the rules of the GDPR also in the AI development. So it's not because we have new possibilities for the Commission to act in our legislative framework about AI that we don't apply continuously the GDPR and the rules of the GDPR. And so my main issue for the moment is to see how it's possible to enforce better the GDPR.
Right. Mm-hmm.
And first of all, to ask to the member states to invest enough human resources, technical resources, and financial resources in the national data protection authorities. And then, and I've had many discussions with the president of the EDPB on this, to have a better coordination inside the EDPB, because we have tried to avoid a fragmentation with the GDPR, fragmentation in 27 different regulations, and we need to continue to work on a correct and same interpretation and application in all the member states. Mm-hmm. It's one of the arguments that I have with the US when we are speaking about the privacy, because if you have more and more new laws at the state level in the US, you will have a pressure to avoid such a kind of fragmentation and to have a real federal legislation. In the EU, it's the same. We try to continue to avoid fragmentation and so to work at the EU level with the EDPB and with all the national data protection authorities. But if we have had the possibility to give new competences to the Commission, and we will discuss with the co-legislators on AI, it's not a reason why we don't continue to apply the existing legislation, GDPR, also about AI.
Right. I want to follow up on that question, because a little while ago we had a major data event to which you had a reaction. There was the scraping of personal information, phone numbers and things like that on 500 million Facebook users that ended up on the internet. I do believe some of your colleagues, even yourself, your own phone number ended up on the internet. This is probably something you felt a bit personally. As a result of that, you sent a tweet saying, I hope, I'm not quoting, I'm summarizing, I hope that our data protection authorities, particularly in Ireland, are looking into this subject. I'm just asking about the messaging. Is it time to apply a little bit more pressure, a little bit more input from the Commission on enforcement? Are things going fast enough? We have dozens of open investigations. We have a slow cross-border process. What is the message you are sending to the DPAs 3 years in? What is it? What is the time now? We've talked about a learning period. Where are we now with the GDPR? Is it time to change gears?
But I'm sure that it's time to work very hard for a better enforcement, because, you know, the GDPR, we have said that it's now the 3rd anniversary of the GDPR. So it's very recent if you look to the evolution in time about the development of new technologies and the development of social media and other kind of new applications. And of course, we need to go as fast as possible. But as Commissioner for Justice, I have also in my portfolio the verification of the full respect for the rule of law in the member states and in the European Union. I must say that, of course, when we have such a kind of problem like we have had with Facebook, we need first to ask to the National Data Protection Authority in Ireland to engage a dialogue with Facebook and to see what are the possible remedies. If it's not, maybe to go further with actions. It's maybe too long, so we need to think about a fast track for some kind of... We need also to let a real chance for the different operators to explain their situation. So that's the difference, if I may, in the timeline that we have with such a process, a dialogue and maybe concrete actions, and Twitter. Of course, it's easier to react on Twitter on the same day, but without a correct procedure. Sure. And so, about the enforcement, again, the main issue is to be sure that there are enough resources in all the different national data protection authorities. But then, I've had a dialogue with the Irish National Data Protection Authority different times to say that we need to push pressure on such an operator like Facebook to receive informations about what was the situation. And if we don't have satisfactory response, we need to take action. And again, maybe in the enforcement, we will think about the way to organize such a kind of fast track to be more rapid in the way to react. You have seen different kind of problems in the last months and weeks and maybe days or so about the access to personal data. Again, in the last days, it was maybe the access from the US intelligence services to some phone number and more than the phone numbers of EU leaders.
Right. You're talking about the tail end of the big Edward Snowden reveal. We're still getting revelations about that concerning the role of some European intelligence agencies. Thank you, Mr. Reynders, and you got that fast track. I'm going to wrap us up. We're running out of time and not too long, but I want to get a last question in for you because I know that people in the United States are going to watch us and read about this conversation. Do you want to get a common approach with the United States on AI regulation? Is that where we need to be going in order to keep our citizens safe and keep them feeling secure about the development of AI? Just quickly on that.
Yes, of course, because we are sharing the same values, and so we try to engage with a real discussion, not only about the privacy, about the security issue. National security issue is a very sensitive one when we discuss about data protection, but personal data protection, but also we try to do the same on AI. And not only at the bilateral level, I want to conclude to say that what is very important and maybe new with the new administration is that we have engaged discussions to be able to go together to like-minded partners and to try to restart a real multilateral process. Because at the end, is that the goal, to have international standards? And we are open to discuss together at the bilateral level to see how it's possible to engage with others in the same way, like in the OECD, but maybe like in many other fora. And that's very new, to see that we have a new partner to engage a multilateral discussion.
Well, you heard that. The door is open. Now the U.S. just has to catch up on AI. I'm going to wrap us up with a big thank you, Commissioner Didier Reynders, for joining us today. We've had an open discussion, and we've had some interesting news lines for you. We've heard about you saying that, in principle, we may be a matter of months away from the very foundation of some new replacement to Privacy Shield. We've heard you say you're going to be vigilant on the UK adequacy deal, and you're going to be ready to hit the pause button if things go awry. We've heard you talk about facial recognition, defend the legislation as it stands on the exceptions as we go into the discussion, the institutional discussions. And we've heard you say that on the GDPR, you're ready to look into a fast track for urgent questions that concern all European citizens. So thank you so much for coming in today and this conversation, Mr. Reynders. I'm going to turn to the next session, which is a panel discussion that's going to dive deep into the nuts and bolts of the EU's recent AI rules, starting in a couple of minutes with our AI correspondent, Melissa Hakela. So stay tuned. Thank you so much.